Good morning. Welcome to the Maryland Public Service Commission's rulemaking session in docket RM72. We are on the record. By notice issued on June 29th, 2021, this is the designated time and place for the Commission to consider final adoption of the proposed regulations regarding the contents of applications for certificates of public convenience and necessity, among other related issues. On March 29th and 30th of 2021, we held a rulemaking session attended by staff and interested parties to consider changes and additions to regulatory text in chapters 1, 2, and 3 of Title 20, Subtitle 79. Upon approval of these proposed regulations at our March 30th, 2021 rulemaking session, they were published for notice and comment in the Maryland Register on June 18th, 2021, and interested parties were given until July 19th, 2021 to file comments. Timely comments were filed by the Office of the County Attorney for Frederick County and the Maryland Utility Scale Solar Coalition. Additionally, on August 3rd, 2021, Commission staff and the Department of Natural Resources Power Plant Research Project filed a joint reply to the comments filed by Frederick County. Those pleadings have been reviewed by the Commission, and the Commissioners may wish to inquire of the parties before us today. However, as the Commission considers final adoption of these proposed regulations, I'll ask if any of the parties wish to be heard at this time. Seeing no parties seeking recognition,
I would ask to be heard. Well, at the appropriate time when the discussion occurs on the proposed provisions.
Ms. Kearney, would you like to make an appearance, and do you have a statement to provide at this time?
I do.
Okay, if you could please start with an appearance.
Sure. Wendy Kearney on behalf of Frederick County, Maryland, Senior Assistant County Attorney. And Frederick County appreciates the opportunity to participate in this rulemaking process with the shared goal that the final product is consistent with the actual processes that the parties will utilize who are participants, and that the rules adopted are parallel and in conformance with the enabling provisions of the public utility article. Do you want me to go at this time through the specific changes proposed?
Well, the Commissioners have reviewed your proposed changes. I believe they were just solely to Chapter 1 and Chapter 3 of the relevant subtitle. So we have gone through them. If you'd like to provide a high-level summary, you may do so. But there's
Certainly.
no need to go through them line by line.
Okay. There's been a constant theme, at least with the county submissions, beginning in October of 2020 and February of 21, and again during the hearings in March, that the process when you're talking that the pre-application process has consistently omitted reference to obtaining the recommendation of the governing body, and that provision has been a longstanding provision in 7207. It was not the newer provision that has that were added a few years back. So the recommendation of the governing body again has been a longstanding requirement and should be included in what the applicant requests of the local jurisdiction. So again, that has been raised several times, but never was added into the regulations. It was even, comment was pre-drafting. And the other changes are, again, a reflection of how someone would obtain information from a county entity. Example, submitting an application, and again, local jurisdictions don't provide preliminary reports unless they have received an application, and in that instance, they will respond to the specific request. I think most of the changes are, again, to conform with practices that would be held in the local jurisdiction. And then the clarifications to the environment information. This was intended to keep the separation between the RPS standards, which again are accounting and reporting provisions, from the actual environmental concern is typically, are they a renewable on-site generator or is it a greenhouse gas emitter? And again, that takes it down to the core of the type of generating facility it would be. And the last change was directed at employment efforts because of testimony that has occurred in the cases I've been involved with that talks about, employment, but it's employment in other jurisdictions where the solar panels in those cases are manufactured, and then they have specialized teams that come from out of state to install those panels. So there really is little or no local employment or positive impact to the local economy, other than for the brief period of time some crews from other states come in and perhaps rent hotel rooms, etc. But there's no ongoing local employment, which again, if you're looking at socioeconomic, you're looking at local employment opportunities.
Ms. Kearney, if I could interrupt at this point and ask you, your proposed language states that there would be a requirement that it would be individuals, quote, living near the proposed project site. What is the definition of living near? Is that 1 mile, 10 miles?
Well, it's certainly from the local economy, as opposed to out-of-state workers. Again, the testimony has been that crews, they're roving crews that do these installations, so they come from not from the local workforce.
To be clear, is your definition of local in-state any Marylander or Maryland-owned business?
Well, given Frederick County's geographic location, Frederick County local employees also come from slightly, the border. We border with Pennsylvania, so a lot of the workforce comes from Pennsylvania, some from Virginia. Commuting distance, as opposed from a crew that all comes in together and leaves together. I'm talking about people who commute locally to work on site.
Okay, well,
come in and go home at night.
Understood. That's hard to reduce to regulatory text, because at first I thought you were referencing Maryland citizens or Maryland-owned businesses, but if the crew is coming from Chambersburg, just across the line, you would make an exception for those crews to be considered local as well. Is that right?
Correct.
Okay, thank you.
Ms. Kearney, can I follow up on that?
Certainly.
What if the crew was from Prince Frederick? Would you consider that local?
No.
How about Westminster?
Of course.
Yeah, you get my point.
I understand, but either they're a Maryland corporation, because I'm very familiar. I do procurement work for the county, so we contract with corporations from all around the state to do various business tasks. But typically, they come do the work, and they go home at night. They come back the next day. It's not somebody coming from Georgia with a crew of however many people they bring, 20, 50. They come from Georgia, they stay here 2 weeks, 4 weeks, 8 weeks, however long it takes to do the job, and then they pick up and leave and go back home. We're talking, again, people who benefit the local economy because they pay Maryland taxes, again, with the exception of over the line, but again, it's more a employing local companies to do work. And with the from what I've seen and heard during the testimony in the cases we've had, the most of local work would be perhaps doing the screening and then maintenance of the screening. So you're just talking about a landscape company, but that's about it as far as local employment.
Understood. I think I understand your intention. The wide variety of potential interpretations of such language may be problematic in future.
Yeah, and again, it's just seeking clarity so that the application doesn't say, oh, it's going to employ, 100 people or have some impact on the local economy when it really isn't a permanent local jobs. Let's put it that way.
Thank you, Mr. Chairman.
Thank you.
Do other commissioners wish to inquire of Ms. Kearney? Do other parties wish to make any statement or provide any response? Seeing none,
I think Mr. Bugleman started to speak.
oh,
I would, Your Honor.
thank you. Sorry, Mr. Bugelmans. Good morning.
Thank you very much, Mr. Chairman, Commissioners. David Buglemans on behalf of USEC. I would like to briefly respond to Frederick County's comments this morning. With respect to the proposed changes to COMAR 2079-0105, with respect to the recommendation of the local governing body, the regulations do not foreclose, as proposed, the local jurisdiction providing a recommendation as part of the pre-application consultation process. And in addition to that, there would still be an opportunity for counties to provide input and the recommendation up until the evidentiary hearing. So I don't think, as proposed, these regulations would foreclose that from happening. I think respectfully, the remainder of the changes proposed by the county are mostly stylistic and wouldn't really change the pre-application process. For instance, Ms. Kearney referred to making some changes to make clear an application needs to be provided to the county. But if you look up earlier in the proposed regulations, it's clear that the draft environmental review document needs to be provided. So I would submit that the remainder of the changes would not meaningfully change the pre-application process. With respect to the changes to the environmental information under 2079-0302, I have a few quick comments here. First off, the change to the language requiring a general discussion of renewable portfolio standard benefits to a reference to renewable on-site generator, it's our position that unnecessarily narrows the proposed regulations. If you look at the definition of a renewable on-site generator, that refers to a tier 1 or tier 2 resource that is going to be used on site. So as published, the regulations would require the application to include information as to any RPS contributions or not. But with this change, it would be limited to whether it's an on-site generator. And I would point out that most on-site generators would be 2 megawatts or smaller and qualify for net metering and not require a CPCN. Or if they were larger than 2 megawatts, they would be eligible probably for a CPCN exemption. So it's our position that change is not necessary. And it's a similar concern related to the proposed changes about greenhouse gas emissions. As proposed, the regulations would require discussion as to any emissions reductions or additions as a result of a facility. But as proposed by Frederick County, it would really only apply if the applicant was proposing a non-renewable source. So it's our position that the original language was appropriate here, and we urge the commission not to make those changes. And then finally, with respect to local jobs, again, we also believe here that the original proposed language is appropriate. If a party has concerns about where the jobs are coming from, it's perfectly fine for that party to conduct discovery or take a position on that in the case. But What this would do is it would narrow the scope of the provided information, so there wouldn't be a requirement to provide any other information on jobs coming from elsewhere. So again, we, as stated in our letter, we urge the commission to move forward today with the regulations, and we appreciate your consideration today.
Are there any other parties that wish to be heard?
Just a quick comment, Mr. Chairman.
Mr. Greger.
Thank you. James Greger on behalf of staff. Good morning, Mr. Chairman, commissioners. We don't have much to add beyond what our comments stated that were filed on August 3rd, but we do believe that many of these points were brought up in the public hearing that took place on March 29th and 30th, and that the additions that are being proposed by Frederick County don't add anything to the regulations as they've already been proposed. Thank you.
Thank you. Seeing no, Ms. Mocklemore.
Yes, on behalf of the Power Plant Research Program, Sandra McLemore, I just wanted to add that in the Power Plant Research Program's Program Assessment Report, we do include information about impacts to the economy, both local and statewide. And typically we include the commuters versus those that are not. That kind of information is included typically in the Program Assessment Report. And I just wanted to bring that to your attention. Also, I just wanted to say that we also agree with the commission staff's comments that were provided in the response letter. Thank you.
Thank you, Ms. McLemore. Do any of the commissioners have additional inquiry of the parties? Seeing none, and having reviewed the Frederick County proposal as well as the responsive pleadings, I don't believe that any of these additional proposed edits would meaningfully modify or substantively change the proposed regulations. So with that, I will propose to my colleagues, and I would move that the commission finally adopt the revisions and additions to the existing regulations as published in the Maryland Register on June 18, 2021, subject to any non-conforming changes necessary to conform to COMAR drafting requirements. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved, and these regulations are now finally adopted and will be published in the Maryland Register. With no additional business on this rulemaking agenda today, this rulemaking session is now adjourned.